Good morning, everybody. Thanks for joining us. Got a special guest here with Sam. Sam is smarter than me in a lot of areas, but especially when it comes to insurance. And so we're going to kind of talk today. This is a little different. It's not going to be Professor Andy lecturing at you like I like to do. And those of you that have attended some of my past webinars knows I like to talk about history and I like to talk about the law. We're going to get super pragmatic and practical today in talking about something that I admittedly am not an expert at, which is why I brought along Sam. Sam here again is a Vice President and National Sales Executive at Mylo. Mylo is a partner with myHRcounsel, and their contact information, there's a slide at the end where you're going to be able to get a hold of Mylo, and they understand our business, and Mylo is going to help you out with any insurance needs that you guys might have that crop up because of questions or something that you see today in our webinar or something that you're thinking about. So without further ado, let's get right into the agenda. We're going to talk a little bit about a whole bunch of stuff in terms of insurance. We're going to start out focusing on the employment law stuff. And then we're going to go into some more general commercial insurance stuff. But before we get that, Sam, I don't know if you wanted to give a little quick overview that does more service to Mylo and to yourself than I've done.
Sure, Andrew, thank you for the introduction, and thank you for allowing me to be a panelist today, and look forward to answering any questions from the participants. So again, my name is Sam Stallard. I work for Mylo. I have been in the property and casualty insurance business for 25 plus years. Mylo, we are a digital insurance technology firm. We write property and casualty insurance in all 50 states, and we have embedded our technology directly into the myHRcounsel website. So if you are ever looking for insurance coverage, by just answering a few simple questions, our what we call our proprietary software platform that we've built called the Mind of Mylo, within just answering a few questions, we're going to make coverage recommendations and match you up with the right carriers that have an appetite for your risk. So feel free after this call if you want to click on that link, or if you wanted just to talk to someone directly in our sales center in Kansas City, there's also a toll-free, there's a 1-800 number at the end of this slide deck as well, if you wanted to talk to one of our licensed agents.
Thanks, Sam. All right, we're jumping right into our first substantive slide here. And I just wanted to talk about employment law in general. I've been practicing law for 21 years now. I graduated law school almost 21 years ago, probably next week, I think. So I've been doing this for a long time. And I've been doing labor and employment law for 19 of those 21 years after I was a prosecutor. So I've seen some things, and I've seen some trends over that time. And I just want to let everyone know, from my perspective, as an attorney and not as an insurance specialist or an expert, and a guy who only knows what insurance is on a broad basis, that employment claims are not rare. It's not like, oh my gosh, it's not like hitting the lottery. They're common. They might not all result in lawsuits. They might not all result in filings with the EEOC or your State Department of Human Rights or whatever equivalent you have. They could be just a complaint about a boss. And all these things, these little microcosm, these little snippets of actions, if you don't handle them right, can really fester and grow into claims. These employment law claims, they generally arise from routine decisions, not because some supervisor says, you know what I'm going to do? I'm going to cause a lawsuit today. They woke up and chose violence. That's not normally what happens. And people are kind of amazed at when they get these claims, defense costs. No company understands how much it costs to go to trial. I mean, the rule of thumb I used when I was doing more litigation work about, I don't know, 15 years ago, it was that it's going to cost you $7,500 to get to summary judgment. That number is probably well north of $10,000 by now. And that's just like the beginning stages of a claim. And then after that, you got trial, you got a whole bunch of nonsense. So it's not cheap. And besides the dollar factors involved is, there's emotional cost of the employees involved. Are they distracted at work? Are they going to be performing up to their normal capacity? Is your management distracted by a lawsuit that, could have been avoided? So usually when I describe a lot of this to our clients, the next question they always ask me is about insurance. I have insurance, or doesn't insurance cover this? And they ask whether there's coverage for these situations, and they want to know what's covered and what's not covered. So this is why we brought on Sam. And Sam, from your perspective, what types of employment-related risk cause employers the most surprise when they actually see a claim filed against them?
From the surprise perspective, I just think, again, we work with a lot of small companies, 1 to 50 employees. It's the lack of communication. Usually the HR department or maybe the CEO doesn't know that something has actually been going on for a period of time, just because they're afraid of some kind of retaliation from a supervisor. So it's just actually typically when a claim is actually filed, or when suit is brought, or a complaint is brought, is typically the first time that a lot of employers, that I've seen, even know about a situation.
Interesting. So are you saying that the frontline employees are trying to handle it without it, becoming a big issue, and then all of a sudden it does?
Exactly. Just trying to mitigate it themselves without actually reporting it up the chain, just because they're, typically a lot of employees are afraid of the causation of potentially of retaliation.
Yeah, makes sense. They're trying to cover their own end. And before we jump into the rest of these slides, I've got some hypotheticals coming up. Maybe Sam, I'm going off script, so FYI, but just basically from an employment law perspective, or employer perspective, what types of coverages are we looking at? Like, I know about EPLI and work comp, but what other types of employer coverages are out there just for the employer side of things?
Sure. So obviously, work comp is going to protect an employer against any work-related injuries of an employee. EPLI claims are going to cover any, type of wrongful termination, harassment, retaliation claims, things like that. That's probably the biggest employer coverage that we see, outside of, general liability, which is going to protect an employer against any type of third-party property damage or bodily injury, which would be, if you are a retail store, a slip and fall claim. Those are what we see a lot. Or if you're in the food and beverage industry, food poisoning, things of that nature. So there really is a host of about 5 or 6 different coverages, which I know that we'll get to later on in this slide deck, that, when we're talking with an employer or a prospect about coverage for a business, we have a great checklist to make sure that, all of the different exposures that a potential business can face, can be addressed by an insurance policy.
Awesome. Thanks for going with me on that. We're going to talk a little bit more, I guess, about in depth about insurance. And so a lot of my friends joke with me when we're having a beer at a happy hour or something. They're like, why do people even have you? If they have insurance, when they get sued, why do they need a lawyer? Why don't they just submit their claim to insurance? So they're basically saying, isn't insurance a substitute for basically good employment practices like compliance, training, or good management? So Sam, I guess that's my question for you. Is insurance an acceptable substitute for good business practices?
Good question. I think, insurance is kind of that necessary evil. It's something that all small businesses need to purchase that they hope that they never use. There are some people that buy it just for compliance purposes. It very well could be you are a franchisee and your franchisor requires you to maintain certain levels of general liability coverage. If you're getting a loan from a bank, there's going to be insurance requirements that are needed to secure that loan. But, having insurance is just one thing. But, if you implement, you have an HR handbook, if you do risk evaluations on an annual or quarterly basis and provide adequate training, you're setting yourself up for good practices where you are going to probably be able to mitigate 90% of any claim before it actually occurs. So it's to me it's a combination of everything.
Makes sense to me. So we talked just briefly a little before about EPLI and work comp. Just at a high level, Sam, what types of employment claims do you think are typically the reasons that employers are looking at EPLI or similar products? I guess work comp speaks for itself, but
yeah. So EPLI is basically covering an employer against any employment claims, but I think what a lot of people also need to remember as well that it's also going to cover claims against third parties. So it could cover claims against a customer who has been turned down for service or not sold goods as well. So it goes more than just the employer-employee relationship. It's also the customer relationship. But typically the types of claims that you see a lot of, I think when you look at statistics from the EEOC, retaliation claims are typically the most frequent, and that's usually retaliation is going to be a causal connection between a protected activity and a negative action. So for example, an employee gets terminated after they file some kind of a complaint, or they make a complaint and they have a negative performance review that leads to a termination, or they're demoted or they have a reduction in hours. So retaliation is typically the top of the EPLI claims. Then you have that kind of followed by harassment, disability claims, and then also race claims as well. And then there are other types of claims that have sub-limits to policies, which I know we'll talk about in a couple of other slides.
yeah, it's actually interesting. I don't think I knew that you could have a claim. Let's say if you're a salon and you're accused of sexually harassing an employee or a client. I didn't know that EPLI would cover that. That's really interesting to me.
Yeah. Most policies, you have to look at the policy, the coverage forms, but most policies will actually provide coverage for third parties as well.
Interesting. So getting back to timing on this, if an employer were to receive a complaint under EEOC or similar, how should they think about timing and notice to their insurance carrier?
Yeah, good question. I would say timely notice is the most important thing when filing a claim. Sometimes, again, a lot of employers might not know that something might be going on until a complaint has actually been filed and they're actually having to respond to that. So, as soon as a claim, an EEOC claim or something from the state has actually been noticed, that's when you call your insurance broker and you call your carrier and you submit you submit the first report of loss, because at that point in time, then the insurance carrier and their attorneys are going to start the investigation process immediately. And the longer it goes, you might not have all the documentation, you might not remember all the facts. Some of those employees that maybe were there are no longer there, and so it's just as soon as you know about it is when you should turn it in.
All right. Does that include, like, if I get a nasty gram from an opposing counsel from an attorney saying my client was discriminated against by you? Would that count?
I definitely think that would actually, I certainly would not want to respond to that on my own as an employer. I would certainly want to turn that over to my insurance carrier and let the insurance carrier that's appointed to the case respond to that letter from a plaintiff's attorney.
That's good, because that's usually what I counsel. I mean, not usually, it is what I counsel clients, and I let them know. And you can correct me if I'm wrong, Sam, that if they wait too long to notify their carrier of a claim, they can be denied coverage even if they had a valid coverage and a valid defense. Is that right?
That is correct. I mean, these are, especially from an EPLI perspective, if we really want to get into the weeds, it is, there's going to be a retroactive date, and there's typically a time frame involved with an EPLI claim versus a general liability claim. So yes, the timeliness is the most important thing.
Yeah. So worst case scenario, they say you're too early, come back later.
Exactly.
All right. I did talk a little bit about the last two questions here. Defense costs. That's something where clients are going to feel the pain in terms of any sort of claim. Can you explain typically how defense costs interact with policy limits?
Yeah, that's a good question. So typically with any type of policy, especially an employment practices liability policy, an insurance broker is going to be able to offer different coverage limits in what we call a self-insured retention. And typically the higher the policy limits, the more the premium is, but that can be reduced by a self-insured retention, or basically what the employer is going to pay out of pocket first before the policy would then actually respond with indemnification. So essentially the way it works is most policies, let's just say you have a $1 million per claim limit with an aggregate limit of 2 million. Some policies, depending upon the type of policy, you can actually ask for defense costs with inside the limit or outside the limit of coverage. So if you have $1 million policy with defense costs inside the limit of insurance, and let's just say the defense costs were $100,000, that total coverage limit of $1 million is eroded by 100,000, or 900 is left after your defense costs. Does that make sense?
It makes sense to me. One final question before we move on to our hypotheticals. What are companies most surprised about, these small and mid-sized employers, about what might not be covered, or what coverage gaps that they have when they actually do receive a claim?
Yeah, good question. It's whether or not the defense costs are within the limits, or within the limits of insurance, or outside the limits of insurance. And again, other things as well, endorsements to the policies, making sure that coverage is afforded for third-party claims. And then the other one would be for, and again, I think we're going to talk about this in another slide as well, but I'll touch on it, is what we call wage and hour claims. When you think about wage and hour claims, you're typically looking at industries that are in the retail, hospitality, food and beverage, or healthcare, where you have those non-exempt employees that might file a suit because they're not paid overtime. They're told to work off the clock, and a lot of those types of claims are typically not going to be covered unless you have a specific endorsement for wage and hour on an employment practices liability policy.
Interesting. Yeah. Let's jump in to some real world real world scenarios. Hypothetical here, we got a 75 employee company that has a dozen shift supervisors, and they call them exempt, and they pay them a flat salary. In practice, the supervisors actually spend most of their time doing the same thing that the hourly work non-exempt employees do. They don't have any independent authority over hiring, scheduling, or discipline. Those of you who love the Fair Labor Standards Act will note that this is specifically written to cause doubt as to whether or not these supervisors are truly exempt or not. After one of the supervisors is fired, the supervisor files a claim alleging misclassification and overtime. There's big time damages potential here. So my question for you, Sam, is how does insurance typically respond to wage and hour claims, which we just mentioned, and what parts of this scenario might not be covered?
Good question. So if an employer did not have that wage and hour endorsement on their policy, this type of scenario would be coming directly, this would be a self-insured claim by an employer. So typically, again, like you talked about, when you think about EPLI, it's difficult to get wage and hour coverage in the retail, hospitality, food and beverage, and the healthcare world. So that's something that you have to, as a broker, specifically has to look for. And typically what happens with wage and hour claims is we talked about that limit of 1 million, 2 million, the 1 million per claim, 2 million aggregate for an employment practices liability policy. Typically, if you have the endorsement for wage and hour, it's usually, Andrew, only a sublimit of typically maybe $100,000 per claim with an aggregate of $250,000. And that usually is only going to cover defense costs. Rarely does it cover actual indemnification from the claimant itself.
All right. So basically, you're saying it's only going to pay for your attorney's fees. It's not going to pay for the unpaid wages and the damages, double damages, usually for unpaid wages.
Correct. And unless you can actually find a carrier that wants to pay those and add the indemnification expenses, but it's really hard. These claims are typically, you don't see a ton of them, but the severity is why a lot of carriers don't actually offer the indemnification limit anymore, just from the standpoint that most of these end up as class action lawsuits.
Yeah. And that's my next question. When I was writing this, I wrote it two different ways, and I thought I edited it, but I messed up. No, Dan, we're still on this slide. Let's say the supervisor that was fired teams up with some other supervisors that were fired, and all of a sudden this now becomes a class action. Does the fact that it's a class action in and of itself change anything from insurance, Sam?
It's a great question. I mean, I'm not a claims adjuster, but there very well could be, a couple of different claims, that are ongoing here. I mean, obviously you have the firing of the employees, that could be considered retaliatory. But the other thing as well is if they're looking for, for back pay and things like that because they were classified as exempt versus not exempt, that to me would be, a second scenario here where it would be, a wage and hour situation.
Yeah, and that would fall under whether or not you had the appropriate rider, similar to with your car insurance if you have uninsured motorists or underinsured motorist coverage on your vehicle.
Exactly. So that's why it's always very important, when you're working with a broker, that a broker is able to identify what types of industries they are in, asking the right questions about, hourly employees and overtime, and making sure that that they make their employer or their prospect aware of this is a potential, claim scenario here. How would you like to be covered for this? Because the last thing you want is to be filed, to have a complaint against you and realize that you don't have the right coverage in place.
Yeah, so I'm hearing, and maybe I'm putting this together myself, but there's a theme here. Claims arise and companies the higher ups usually become aware of it because of lack of communication. So you need to make sure your org's got that communication, but also you need to do some communication up front with your broker to make sure that you are protected to the amount that you want to be protected. And without, with its hopes and wishes, yada, yada, yada. If you have hopes and wishes were loaves and fishes type of thing. If you just think, I thought about having this coverage, but I never actually talked to my broker about it, you're probably going to be left holding the bag.
That is correct. And the other thing I will say as well is, if an employer is aware of a potential claim and they don't have coverage, but then they want to get, an insurance policy in place, most applications are going to have what's called a warranty statement, where they'll ask the question, are you aware of any activities that have brought a claim or could bring rise to a claim? And if they answer that question as yes, the underwriter is going to want to get details about that scenario. And for the most part, what they would probably do is they would probably exclude that from any policy moving forward.
Yeah, that makes sense. You can't have buyer's remorse and try to cover yourself after, let's say you get in a car accident and you can't buy insurance later to cover it.
Exactly.
I love analogies, Sam. I don't know if you can tell.
That's great.
Our clients that get tickets answered by me probably like enough with the analogies. But let's move on to the second hypothetical here. We have a 58-year-old employee who's got 22 years with the company and has had consistently strong reviews and is laid off in a RIF. 3 of the 4 employees also selected as part of the RIF are over 50, while younger employees in similar roles are retained. A manager's email refers to the needs for quote unquote fresh energy on the team. Those of you paying attention might be smelling what's coming. The employee files an EEOC claim alleging age discrimination. That doesn't get resolved at the federal or state level, and then files a federal lawsuit seeking back pay, front pay, emotional distress, et cetera, under the Age Discrimination and Employment Act. So Sam, what point would coverage usually kick in for a scenario like this? And how, we're not going to get into defense costs. I guess that's on my next slide.
Yeah, typically, if once the EEOC claim once the EEOC charge has been filed and it's presented to the employer, then that's when the employer should notify their broker and their carrier, of a potential claim and turn it over to investigation at that point in time.
Yeah, and I'm going to go maybe a little off script again. I know this from personal experience that insurance companies work differently. Some have panel attorneys where if you submit a claim to them, let's say a discrimination claim, they're like, all right, these are the attorneys you have to pick from that can defend you. Sometimes they defend a claim and sometimes they will reimburse you for defense costs sometimes. Does that sound about right, Sam, in terms of how EPLI might handle this for an employer choosing an attorney?
Yeah, most insurance carriers are going to have, engage with different law firms based upon which region of the country you're in. And again, all employment practices liability policies are going to have that self-insured retention. So once the claim starts, the clock is ticking, the meter is running. And let's just say the employer has a $10,000 self-insured retention, they're going to pay the first $10,000 of those investigation legal expenses, and then after that limit has been after that self-insured retention has been exhausted, then the carrier is then going to be on the hook for the remainder of those defense costs. Again, depending upon whether it's inside or outside of the limit. Plus any additional indemnity that might be paid to the claimant themselves.
Makes sense to me. that's all I had on this one. So let's go to hypothetical number 3, and we're going to talk about harassment. We have an employee that reports her direct manager has made repeated sexual comments and unwanted physical contact over several months. 2 coworkers say they witnessed similar behavior and had raised concerns informally a year earlier, but nothing was documented and no action was taken. Editorial note, always paper to file. The company has never provided anti-harassment training, has no written reporting procedure, and cannot produce records of how prior complaints were handled. The employee files an EEOC claim, a Title VII lawsuit seeking compensatory and punitive damages, and with the absence of training and documentation, severely undercuts the company's here affirmative defenses. So Sam, this is maybe less on the lawsuit side, but the upfront side. So in terms of training and policies and employee handbooks, how does that affect underwriting or claim handling, or do you get a discount if you have a really fancy employee handbook or something?
Great, it's a great question, because that is one of the underwriting questions that all carriers are going to ask. Is they're going to ask, again, are you aware of any claims? How many terminations have actually happened in the past year? They're also going to ask if you have an HR director, or if you have a handbook, or do you have written employment and employee guidelines and policies and procedures in place to handle situations like this. So yes, the carriers they want to know that you have implemented best practices regarding employer-employee relations, that you have an employee handbook, that it is updated, and that you are following these procedures, because if they know that you've taken, you've tried to mitigate the risk as much as possible up front. If somebody answers that question as no, we don't have an employment handbook, no, we don't have guidelines or policies and procedures in place, typically what's going to happen is I'm usually going to get a declination from my carrier and say, sorry, this is a risk that we do not want to insure. Or if an underwriter does want to take a chance on that risk, you're going to see your premiums, elevated substantially, because the risk of a claim is going to be higher, and the chance of an attorney being able to defend that employer is probably not. Their defense isn't going to be great, because they don't have any records of what had been done in the past for that specific claim scenario.
Yeah, and I will just note too that we at myHRcounsel, I love court. I was in court 40 hours a week when I was prosecutor, pretty much. Our goal here is to keep you guys out of court. So before you guys do anything, always check with us. Always submit a ticket and have our attorneys help you out. Because even if you do have insurance, it's still not free and it's still not cheap. So you want to do everything you can to avoid these nasty situations if you can. All right, hypothetical 4 is our last hypothetical, and this one gets into math, Sam. And so I don't do math. I'm an attorney. There's a reason I went to law school, not med school. But here it is. An employer carries an EPLI policy with $1 million aggregate limit, defense inside limits, and $25,000 retention. In the first half of the policy year, there's a wrongful termination suit that goes to mediation. In that, defense fees and settlement consume $450,000 of that $1 million aggregate. A couple months later, in the same year, an unrelated class action alleging discrimination and wage and hour violations is filed. So what does that mean for the employer in terms of their annual limits? Like, how does the math work with that 1 million and that 450,000?
Yeah, good question. So an aggregate limit is the maximum that an insurance policy will pay for any number of claims in any one policy period. And most policy periods are going to be 1 year. So in this case, you have the self-insured retention of 25,000. Then you also have your settlement of 450,000. So that is eaten into our aggregate limit. And what would be available for that insured for the remainder of that policy period will be 525,000 would be left for any potential EPLI claims that might occur during that policy period.
Yeah, any covered claims, yes.
Yes.
Because unless you have the rider for wage and hour, those are probably going to be out anyways.
That is correct.
Yeah. So, and then there's, I think you talked about that, but there's also per claim limits, right? So if this is $1 million aggregate limit, I'm guessing that their per claim limit would be less, maybe 750 or 500,000.
Yeah, carriers will give insureds multiple choices. So it could be a $500,000 per claim limit with a $1 million aggregate limit. It could be 750 per claim with a 1 million aggregate, or it could be 1 million per claim with a 1 million aggregate limit. So again, the higher the policy limits, the more exposure that the carrier is up has, so they charge more premium. So if you go with a lower per claim limit of, let's just say 250 or 500,000, you're typically going to have a cheaper policy.
Right, but then you have exposure if we go over limits.
Correct. Yeah, you would, if let's just say in this claim scenario, you had a $250,000 per policy or per claim limit. Once you reach that threshold of 250,000, the insurance carrier has exhausted their limit, and then the remaining 150,000 would then be covered by that insured out of their own pocket.
Understood.
200,000.
All right.
Sorry, 150. Yeah.
Well, I'm not here to pick on anybody's math.
That's okay. That's my University of Kansas math for you right there.
All right. We're going to leave the hypotheticals behind, and we're kind of going to leave employment law land behind, because there's more to insurance than just employer coverages. So Sam, I'm going to let you talk more intelligently than I can about the different types of coverages that exist for commercial lines, beyond employment law issues such as the ones I have listed here.
Sure.
So can you just run me through maybe a brief overview of what you guys are looking for in order to help companies protect themselves?
Exactly. So if we're working with a prospective small business owner, the most common insurance policies are either going to be what we call a BOP policy or a business owner's policy, which that's going to provide coverage for any property. So think if you own your building, that's real property. A BOP policy would cover the property. If you don't own your building, but let's just say you lease space and you have improvements and betterments that you've invested into that space, that BOP policy is also going to cover that tenant finish and improvement. And then any business personal property or any assets the company might have would be protected as well from a property exposure. Along with that BOP policy, you're going to have your general liability. And the general liability is just basic third-party bodily injury or property damage. So that's going to cover an insured against any trip and fall claims, any food poisoning that we had talked about as well. Then you're also going to have other exposures as well. Cyber liability, that's a relatively newer coverage form that came about in the last 10 to 15, probably the last 15 years. That's going to cover anyone for any type of data breach, any type of business email compromise, fund transfer frauds, and or human error. Other types of policies, if you do have employees, workers' compensation is required by every state for every employer to have workers' compensation coverage. Then you also think about, does the company own vehicles or not? there certainly is always going to be an auto exposure, whether or not a company owns vehicles. And then obviously we talked about the employment practice liability. And then, again, for certain types of businesses, there's going to be either what we call an errors and omission or a professional liability exposure. So if your business provides any type of professional services to their clients or customers, there definitely is a professional liability or E&O exposure. Think of law offices, think of accountants, think of real estate agents, think of insurance professionals. We all have a duty to provide, professional services and a duty of care to our clients. So we have that additional exposure right there of professional liability.
Yeah, I know. We have malpractice coverage for sure. I have to tell the
Yes.
state bar every year who it is and who my carrier is and all that fun stuff. I have a whole list of questions here for you, Sam, but
Sure.
I don't know that I want to get too deep into them. But and maybe just selfishly, like I have E&O and D&O on there, and I honestly don't know what the difference is between errors and omissions and directors and officers coverages.
Yeah. So so E&O or professional liability, again, that's going to cover, it's going to protect an employer and employees for for any mistakes or that they might make if they're delivering a professional service to a customer. So when you think of professional liability, what would be a coverage trigger for that? It's going to be negligence. You missed a deadline. You gave bad advice. Those are typically going to be errors and omissions types of claims. And then directors and officers, that's really what we also call management liability. And that's going to protect, the personal or company assets of anyone in leadership. Think of, CEO, think of management. And it's going to protect them against any lawsuits related to, management, corporate governance, or, fiduciary duties, for the company. So triggers when you think of a D&O policy would be, that would be, board mismanagement or corporate mismanagement, breach of duty, or any type of fraud. So when you think of a lot of small businesses, the D&O typically doesn't come into play, unless it's a company that's out there raising money or actually has outside investors or has a board of directors. So if you're just running a retail clothing store, you don't have any outside investors and you don't have a board of directors, you typically would not have, in my opinion, the directors and officers exposure there.
How about for nonprofits? Would a nonprofit be something that would be more likely to get a D&O coverage?
Absolutely, because typically most not-for-profits are going to have a board of directors. I sit on a board of directors for the Lacrosse Association of Kansas City, which is a high school and youth lacrosse league. We certainly have directors and officers coverage in place. We're not out there raising money, but we have an exposure if we find out that a coach, abused or used corporal punishment with a player, things like that. We have an exposure and a liability there that we want to make sure that we are protected against. So I would say that most not-for-profit companies should have a directors and officers policy in place. And, for the most part, they are relatively inexpensive, just depending upon the amount of assets that entity or that not-for-profit might have is going to really dictate what those premiums will be.
Interesting. All right, we're just over 45 minutes into this. I think that, the next slide I have kind of maybe, I don't know if you wanted to talk about it, Sam, about is there like one key takeaway when we want to talk about in terms of risk management and insurance Is there a best approach? Is there an okay approach? What are we talking about when you're an insurance advisor talking about coverage to employee companies? I'm sorry.
Yeah, I would say, making sure that the company has a well-rounded insurance policy in place. A lot of these coverages, Andrew, that we've talked about, most of these BOP policies or these business owner policies are going to have some sublimits for cyber liability, some sublimit for EPLI. But the question is really going to be, is that enough coverage if the worst case scenario happened? So, really thinking about the coverage limits themselves is key. And you'd be surprised that making the jump from, let's just say, in a general liability policy, going from $500,000 per claim, jumping up to $1 million per claim, you might only see a difference in price of $30 or $40. So those increases in premium aren't going to be linear to the increases in the actual coverage limits themselves. So what I always tell clients, at the long run, cheap is expensive. You want to make sure that you have coverage to protect the assets and to protect that business that you have spent your time and money, your sweat equity building, so that if you do have a claim, that insurance can actually respond to that, so you can be a going concern.
Yeah, cheap can be costly. I've heard that a lot from my wife, who's a CFO. I like that phrase a lot. All right, Dan, let's skip over to the nice Mylo slide if we can. And for those of you that have questions, make sure you slap them into the chat. And for those of you that have insurance needs, here's your information right here. We got the phone number 844-563-3210. We got the link there on the bottom. As a reminder, you guys don't have to furiously scribble this down super fast. You will be getting a copy of the deck, and you'll be able to get this information and these numbers, and you'll be able to talk to Sam's team about any coverage questions that you have or any coverage recommendations that they might have for you. And I'm sure they'd be more than willing to help you out with any of your business coverage needs, not just your EPLI stuff that I'm mostly concerned about. Sam, anything to add on that?
No, I think we've covered a lot of topics today. Obviously we don't want to try to scare people, but insurance is one of those things that is usually out of sight until you're either coming up on renewal or a claim happens. So I always say, be prepared, have a copy of your policy. If you don't understand or know what the coverage is, reach out to your broker or reach out to us if you have questions, about your existing coverage and whether or not, what you have is adequate to protect your assets. Also, again, I think leaning heavily upon myHRcounsel, they're providing a lot of due diligence and a lot of risk mitigation as well. And it's just a very valuable service that you guys, I would recommend taking advantage of.
Thanks, Sam. Dan, you let me know if we got any questions that came through. I didn't see any, but that doesn't mean anything.
We do. We actually just had one come through. Here's the question. I would like to know if these rules or policies are also applicable for contract workers in healthcare, IT, and the non-IT domain. Contract workers means people are getting hired through staffing agencies and then working for their client.
Very good question.
Leased employees, right, Sam? Or
yeah,
not even, leased employees.
Yeah, I would say that, depending upon the type of coverage, some of those leased employees, could be considered protected under an employer's policy. They will protect leased workers. They will protect, 1099 subcontractors or volunteers. Typically that's gonna apply to most policies except for typically workers' compensation. where, typically that leased employee would have, afforded coverage if they're working through like a staffing agency or somewhere like that, coverage through that relationship.
And I'll add to that in reviewing a lot of staffing agreements. Usually the employer client that's leasing the employee is getting the temp staffing on site. There's contracts shift the risk for who is responsible for any claims. So those also come into play, what your contract says with the temporary staffing agency.
Good point. Yes.
Any other questions for us, Dan?
I think that's all that we have.
Awesome. Well, thanks everyone for joining us. Thanks, Sam, for sharing your vast insurance knowledge. I think we've only probably scratched the very tiny surface of what you know and what you could tell us. But in the interest of time, I would love to talk more. But I'm sure we all have, unfortunately, real things to do instead of learning more than we've already learned. Thank you very much, Sam, for joining us. Anybody
Andrew,
has questions? Yeah.
Thank you very much as well. I appreciate the opportunity.
Yeah. Anybody has questions about insurance, reach out to Sam's team. Make sure you have the coverage that protects your company to the amount that I guess that you're comfortable with. I mean, if you're comfortable driving down the street without insurance and getting in a car wreck, you're more risk averse than I am. But just make sure, talk to somebody who's smarter than me about insurance and get that all taken care of so you can sleep better at night.
All right. Once again, thank you everyone for attending today. If you have any questions on the material covered, we encourage you to reach out to us at info@myHRcounsel.com or through our secure and encrypted portal at ask.myHRcounsel.com, and we can provide you with a specific legally backed answer. We hope that you can join us on a webinar in the near future. Thank you again for joining, and we hope you have a great rest of the day.